Good morning. My name is Nick Gage, CEO and President of the Morgan Hill Chamber of Commerce. On behalf of our entire team, I would like to welcome you to the Morgan Hill Chamber of Commerce's BizDev series of educational workshops. The goal of our educational series of workshops is to inform and educate our business owners and consumers on today's relevant topics of discussion that impact them both today as well as in the future. And today we are so excited and pleased to have on our workshop series the leadership team of Amare Real Estate Services, located in the heart of downtown district, and attorney Adam Ferguson from the Ferguson Law Group. Both teams will help us better understand the importance and the alignment about home ownership, estate planning, and much, much more. So with this as a brief introduction for today's session, it's my honor to present Victoria Tenzio, excuse me, broker owner of Amare Real Estate Services, Cindy Dominguez, realtor and sales manager, and Adam Ferguson, principal of the Ferguson Law Group, who also serves as a member of the Real Property Trust and Estate Law section of the American Bar Association. So with that as a very brief introduction, let's get to the educational series. Please welcome Victoria Tenzio, friend, colleague, and mentor to kick off the session.
Hello, everybody. We're really glad you're here to join us. We feel that this is one of the more important topics. I'm going to go ahead and share my screen now so we can get started. Share, and here we go. There we go. So real estate and estate planning for us go hand in hand. Adam has a wealth of experience and knowledge, and that complements the small section that real estate plays with trust and estate planning, and also probate. So we wanted to have this conversation, invite you all in to join us, and any questions, please let us know. We are here to be of service. So first question, why do we think this is important to talk about? Every time we hand keys to somebody, we ask the question, do you have a trust or a will?
Yes.
And how often do they say no?
More times than you think.
I
Yes.
would say probably 90% of the time in our experience. And this is not just because we're dealing with first-time buyers. It's just because it's one of those things that people don't like to think about all the time, but it's so important. And even if you don't own a home now, but you do have assets, and that can be a 401k, stocks, trusts. Adam, what is the dollar limit in California before an estate would go to probate? What's
About 166,000 bucks.
okay? So
Not a whole lot.
Not a
No.
whole lot, especially in California, especially with stocks and
Yes.
RSUs,
401ks and
everything. So
retirement funds.
if
Yeah.
your estate is valued at more than 167, and you don't have a trust or a will in place, that means that you face a process known as probate. So we're gonna dig into that deeper in a little bit here, but it's very important that you protect yourself, your family, your loved ones by having a plan in place. It's actually a gift, I think, to that family
Absolutely.
person.
Absolutely.
We, my family personally, we lost somebody who did not have a will or a trust in place. One of the most challenging things during that, and I ended up kind of being the business manager of this when this happened, was we just were unclear as to what his wishes were, and that was a little heartbreaking. So I strongly advise everybody to consider doing this, and attorneys like Adam and realtors like myself and Cindy and our whole team here at Amare work closely together when somebody passes, and if they are holding a property that they need to sell, or they determine what they want to do with that. I was recently asked a question, what if we want to hold the property and rent it out? And depending upon what the trust provisions are, that's acceptable and something that we can assist with as well. So we really value working with professionals such as Adam with so much experience in this area. And we all agree that it's not a comfortable conversation when you talk about somebody passing and money, and those are like the
Yes.
topics you avoid in polite company, but it really is a value and so important for all of us to have that conversation before
Something
we're-
happens.
we're grieving somebody.
Yes.
So, with that being said, terms associated with estate planning and probate, I will hand this over to Adam, and there you go.
Thank you. And thanks for having me. I'm excited to do this. I'm, born and raised in Morgan Hill, so anything I can do associated with Morgan Hill, I really take pride in. So I've been an attorney in the estate planning, trust and estates world for 17 years, and even in law school. I worked for a trust and estates firm, so this is something that I've been deeply involved in for quite a while. I like to think I have some pretty useful knowledge here. I also practice litigation, so I get to see the estate planning side of things through the eyes of dispute and dispute resolution. So we can draft with an eye toward avoiding conflict and anticipating conflict. So I think that really helps within our firm for how we handle things. With regard to moving on here to some of these terms, just to give some background, estate planning is a term that sometimes is foreign to people. And it's basically somebody writing down their wishes for what they would like to have happen with their estate when they're gone. That's the rudimentary definition, but there's far more that goes into that. There's decisions about who's going to be in charge, how decisions are made, what happens if somebody passes away that was initially designated as beneficiary. So it's a far more in-depth conversation than I think people really appreciate. It's not as simple as writing up a will or not, or writing up a trust or not. What we're here to talk about today is primarily probate and probate avoidance. And so we'll talk a little bit more about the probate definition and the concept, but some of the terms that come up are personal representative, executor, successor. These are the people that take over when somebody passes away. Okay, when someone passes away, somebody needs to be legally able to sign contracts on the deceased's behalf, sign deeds, sell properties, etc. And that's going to be a personal representative or a trustee, depending on the circumstances. When we're talking about court confirmation, that's going to pertain to confirming the person as being in charge if necessary. And it could also confirm the sale of real property if we're stuck in a probate, which again is to be avoided if possible through a trust. The concept of a financial power of attorney and a durable power of attorney for health decisions. These are really important things that come up when you're alive. They terminate when somebody passes away, but if you were to ever lose capacity due to illness, accident, what have you, a durable power of attorney for finances allows somebody that you've chosen to make financial decisions for you. And same thing with regard to a healthcare directive or a durable power of attorney for healthcare. If you're laid up in a hospital bed in a coma, somebody has to, interface with the doctors, make decisions. Again, you'd like it to be probably somebody you chose, and you'd like to give them some guidelines. And that's what a healthcare directive does. If you don't have a financial power of attorney or a healthcare directive, there's a very good chance if something happens to you, you're going to end up in something called a conservatorship. And that is a court process. Everyone's heard of it with Britney Spears. That's probably the most easily recognizable conservatorship in history. But they're highly invasive public proceedings where, you're likely to get wheeled into court, drooling on yourself, while a judge determines whether you have the ability to manage your own financial affairs or personal affairs. All of that can be avoided. All of the cost of attorneys and court costs, et cetera, can be avoided through very simple planning. And that's what we do, is we help avoid these things that are frankly inevitable without planning. When we're talking about beneficiaries and heirs, beneficiaries are the people that receive assets when somebody passes away, whether that's through a trust, a will, or it could be through a probate when there is no will. Heirs are people that inherit by default. So most people are probably not aware of this, but if you have no estate plan, you do have an estate plan. It's just created by the state of California. And it's a default one, and it's going to leave your assets to your heirs. And that's a changing definition of who those people are, depending on your family situation. Okay, it may be your spouse, it may be your children, maybe grandchildren, it may be parents or siblings. It just depends on who are your closest relatives according to, a diagram that the state of California has formulated. And it's well-intentioned, and it oftentimes arrives at what would be the likely intended beneficiaries of somebody's estate, but not always. And so if you have, potential heirs that either you wouldn't want to inherit from you, or maybe they have some concerns about their ability to handle money, they have concerns about creditors or a spouse, leaving assets to them without some level of planning is going to expose them unnecessarily. And so then when we get down to what is a revocable living trust, that's where you as an individual have an opportunity to not only designate who's going to be in charge of your assets if something happens to you, you then say, and here's what I would like to have happen with them when I'm gone. And that's really powerful, because you can leave assets to anybody. Usually it's children, not always. Usually it's a spouse, not always. But you can do so with limitations, and you get to control from the grave. And sometimes that can be incredibly valuable. Like I said, if you have somebody who's maybe a spendthrift, or they have a spouse that might take advantage, you can set up a trust for that person that they don't own. There's another person in charge of it. They can dole out the money for them, but it's not accessible by creditors or a spouse. And that can be hugely valuable to somebody who's in a compromised position. In the context of how we set up a trust and what it is, it's as simple as an agreement. It's an agreement between two people to manage property, and for another person to receive that property and have the beneficial interest to the property. So it's a legal ownership component and a beneficial ownership component. And so long as somebody's alive and they're the ones who created this trust, they're one and the same. They're the same person. They're their own trustee. They're also the beneficiary. So they can do essentially whatever they want. It's just like they own the assets as they would before they put them in a trust. The only ramifications we start to see are if that person were to lose capacity and now a new trustee steps in, or if that person were to pass away and again a new trustee now steps in, and they're going to follow that roadmap, whether that is to pay out income and principal and assets to the settlor, the person who created the trust, or then to their beneficiaries once they passed away. There's a roadmap there, and there's no confusion about what this person wanted, or certainly less confusion if you've done this with an attorney, because they're going to have notes. They're going to know what was intended. And one way I explain this to my clients who maybe are on the fence about, maybe I can do this by myself. I'm not sure I need an attorney. It's expensive. The way I tell them to justify the expense is not just probate avoidance, which we'll get into, but you're buying a witness. You're paying a very modest fee to have a witness show up when you're gone and you can't express your desires, and they're going to stand up for what you said. They're going to say, I met with them on that day. They knew what they wanted. They told me exactly what they wanted. And so if you're going to now argue about what that person may have meant, I'm here to clear that up. I'm here to testify that they had capacity, that they knew that what they were signing, and that's their signature. So it's a really valuable thing to do this with an attorney, because like I said, they're your best advocate for your intentions when you're gone. Healthcare directive already addressed with regard to the power of attorney.
That's awesome.
Very good. Very good. So important.
Okay. And a little more definitions
Sure.
and some questions that we hear all the time. Adam,
Mhm.
can I have a will without a trust?
You can have a will without a trust. And there are a few scenarios where that works, but not all. And so the three threshold items that I tell everybody where you should not have a will without a trust is if you own real property, if you have minor children, or if you have a blended family.
Yeah.
If any of those three things exist in your life, don't even think about having a will without a trust because you're asking for trouble.
So true.
That's really good advice.
Okay. And even with a will, you go through probate. I think a lot of people overlook that.
Yes.
So wills are documents that you can create either with an attorney, you can do it by yourself, you can do it on a napkin in your own handwriting, as long as it's signed and it expresses that it's a will. I don't advocate that.
No.
But you can have a holographic will that's just drawn up by yourself. And it doesn't have any legal import until you've passed away. And then only after a court has blessed that document and a judge says, yes, I believe that was in fact a will, and now it is probated into the probate. And so now that will is admitted to probate. It's real, it's valid. Now we're going to follow its terms. But
Right.
at that stage, there's an opportunity for people to come out and object, whether they think it's not a will, whether they think it was done under duress or undue influence, or it's a forgery. There's an opportunity there for that to be challenged. And very quickly, with regard to like the handwritten wills and why I advocate so strongly against these,
Yeah.
nobody is around to clarify what you mean.
Yeah.
There is a ton of litigation about holographic wills because either they didn't know who was described as the beneficiary, they didn't know what property the person was talking about. To them, it seems very obvious, but down the road, it may not, right? I give the ranch to Johnny. Great. Your ranch is 14 parcels of land. Is that all of them? What is your definition of ranch? Who knows, right? Let's go fight and pay a fortune to sort that out. One of my longest running cases was a probate that lasted from, the lady died in 91 and it resolved after a trial and an appellate court decision in 2015.
Oh,
So
geez,
was that 23 years? And this old lady sat down, wrote it at her kitchen table, thought there's no way anybody could misconstrue this. But, you know, there was 30 million bucks on the line. People are paid to misconstrue things if there's that much money on the line. So,
Yeah.
to be avoided.
Yes.
All right, where do I start? Great question.
Yes, perfect.
Most people start with Google searches and they acquaint themselves with some of the terms. I don't discourage that. I think it's great to try to educate yourself, but you can only go so far, right? I can Google anything at my home on how to fix something and get a rudimentary understanding, but I'm not going to go redo my electrical box, for instance, because I've got a rudimentary understanding of what breakers are and voltage and so forth. But it might help if I go talk to a professional at that point with that education behind me. But you start with an attorney. Most estate planning attorneys will do a free consult to find out where you're at, what you might need. Not all, but most. And that's a great place to start. What I usually do in those intro meetings is I just want people to appreciate, for better or worse. Sometimes it's, hey, it's not a big deal. You know, you're okay. Not perfect, but it's not the end of the world. I educate them on what they've got right now. Here's your family dynamics. Here are your assets. Here's what happens if you leave my office and get run over by a bus.
Right.
And sometimes they go, okay, let's move, but it's not a big deal. We'll work on this as we go. And some people go, oh my God, I had no idea my brother would inherit from me. I hate that guy. Right. And so it's an important conversation just to get an understanding of what these default rules are.
Yes.
You know, Victoria, you and I have talked about this in the past. Separate property is a huge one. If you have any separate property and you're married, you need to talk to an attorney immediately.
Yeah.
Because it's highly likely that there's a misconception about who inherits that separate property if you don't have an estate plan.
Right.
And it's usually believed it goes to your spouse. That's not true. If you have kids, it's going to go partially to your kids, either 1/2 or 2/3, depending how many kids you have. And that could be catastrophic, depending on your family dynamics and what assets we're dealing with. So, do I need to own a home to have a will? No, definitely not. Everybody should have some level of estate planning. And like I said, you can get by with just a will in rare circumstances, but a trust is going to afford you far more control over situations than a will is going to. A trust governs while you're alive as well as when you're dead. A will only applies when you're dead. And you're going to have to go through probate again with a will. So the home is not necessarily the determining factor, right? Asset values, family dynamics, a lot of other considerations come into play.
Okay.
I own a home, but it is not in my trust. What should I do? You should get it in there right away. Talk to an attorney or a title company if you're comfortable. I know a lot of title companies kind of got away from this in recent years. They're not quite as willing to put themselves out and do deeds for people, one-offs. But attorneys can certainly do this very quickly, very easily. And it's important to understand, we used to have sort of this magic paintbrush we could sweep over mistakes in failing to put assets in trusts. It's a case called Estate of Hegstad. And what it said was basically, if you can prove that somebody meant to put assets in their trust and forgot to before they died, then you can go to the court and the court will say, fine, no probate required. We bless this intention and we're going to put that asset in the trust.
How hard is that to do, Adam?
It's not terribly hard. There's a cost component, maybe $3,000 to $5,000,
right?
Depending. The problem now is, it used to be we could rely on the will, what's called a pour over will that you would have with a trust.
That was my question, is that if you have a pour over will, yes.
Yeah. So a pour over will is a will that says, in case I forgot to put anything in my trust, now that I'm dead, go put it in my trust. And it's very effective at accomplishing that goal. The problem is, an appellate court case came out, I don't know, maybe 5 years ago, that significantly limited the application of that Estate of Hegstad case. And it said, unless you can show me a writing other than a will, where this person said, I want 123 Main Street to be in my trust, we're going to require that it go through probate. So I've had people create estate plans. They've done everything by the book. They sell their home, they buy a new home, forget to put it in their trust, die, and it's as though they had never had a trust in the first place.
Right.
So that's a huge red flag if you do not have your house in your trust and you have a trust. It must be addressed now. I wouldn't have given that same advice 5 years ago.
Interesting.
Yeah.
Interesting.
I don't have kids or heirs. Do I really need to make an estate plan? Honestly, probably more than anybody. Because people don't understand who inherits from them. If you don't have kids, it's going to go to your parents equally. If one of your parents is gone, it's going to go to your siblings, right? So you start to get into this family tree of, you look up to find somebody alive and that's who's going to inherit. If there's nobody there, you look down from them. Siblings, nieces, nephews. If you don't have any of those, you're now up to the level of grandparents and then branching out from there. So you can imagine how potentially broad the heirs could be when you don't have children or grandchildren. That's when things get really interesting, and we have to break out these antiquated probate codes and draw these family trees and go, okay, this person gets 1/12, this person gets 1/24. It can become a real nightmare, and I think it largely comes down to understanding the default, right? People just need to understand that. So absolutely, if you don't have children or grandchildren, talk to an estate planning attorney, because maybe you have a significant other. Maybe you own a home with a significant other, but you're not married. And these are major life situations that are impacted by a death if you don't have an estate plan in place.
Right.
Power of attorney, we talked about, it's basically somebody who can handle your finances while you're alive, but incapable of handling them yourselves.
Right. Very important. I have a question, and I just made a note because I've been through this process once before. This is not on my terms page. I apologize. What is ex parte?
Good question. It's kind of advanced, but good question. Ex parte is accomplishing obtaining a court order without a hearing. So it's without having to go to court.
Okay.
Okay, so take that classic Hegstad petition where you go to court, you say, Judge, this person listed their home on Schedule A of their trust. They wanted it to be in the trust. They refinanced, and so they had to pull it out of the trust, and they forgot to put it back.
Yes.
Everybody agrees. So you've got to have one of those families that gets along. Everybody's on the same page. They all sign off. we can go into court without having to set up a hearing that's not going to be for 60, 90, 120 days out. We could just walk into court, hand our petition to the court or to the clerk, and they'll run that up to the judge, and we can have that signed within days or weeks, as opposed to months or years if there's larger issues. But ex parte is that really fast, non-hearing type order that you're able to obtain in limited circumstances.
So a few years ago, I had a listing, two sisters, the mom had passed. The home had a reverse mortgage on it. So it was not wrapped up in a bow, but that was the process that they went through that basically facilitated the sale. And then they could move forward from there. So
Yeah, so what they had to do was basically an emergency petition to get a special administrator appointed, who then had the authority to sell the house because of these, impending, foreclosure or whatever it was with the fees or what have you with the reverse mortgage. That can always be done. There's a major cost component to that. The attorney is going to make a bunch of money.
Yeah.
All of that is avoided with a trust, right? A trust is seamless. Somebody passes away, a new trustee can be appointed literally that day. It's a couple of documents they sign, they're in as trustee. Whereas through the probate process, everything has to be blessed and approved by a judge.
right.
And court moves slow.
It does. Okay,
Yeah.
move on to the next one. What happens when a loved one dies without a will or a trust? So I think for me, when we have somebody who has gone through a loss and they call us and they have maybe one or several properties to sell, and they always seem to be pressed for time, like they feel like there is a rush. And this can be whether it's a probate or a trust sale. So, but let's start with family members taking action regarding assets, and determining who will act as an administrator. If they have an estate plan in place, that's already determined, correct?
Yeah, so this is an overlooked value of an estate plan. I think people take this for granted. Who's going to be in charge, and resolving that before it becomes a dispute is really important, because when you don't have a will or a trust, you're in probate, and now everybody who is on the same familial level, it's usually children, so I'll use that as my example. When their parent dies, they all have equal priority to be appointed. So if there's 5 kids, all 5 can say, I want to be the person, I want to be administrator. And the only way to sort this out at the court level is they all file competing petitions.
Wow.
And then you have a trial if it gets that far. So now you've got all these people with all their lawyers fighting over who's going to be in charge, which frankly, it's a pretty thankless job. You don't really want it, but human nature, people vie for this position and they really want to be in charge. The only way to get that off dead center for a judge is they can pick one child,
Or all.
all children, or none. And they're leaning very much toward none lately, which is, look, we have an abundance of private fiduciaries who do this for a living. They're neutral. They have no allegiance to any of you. They're just going to come in and do the job. And it's going to reduce future conflict and future court involvement by putting in somebody neutral. So the best thing you can do if somebody passes away without a will or a trust is get together with your family members and maintain a relationship and open communication and decide, hey, who should it be? If you can keep the family in communication as opposed to everybody retreating to their own attorney, then that's your goal. Try to do it acting together in concert. And then hopefully somebody is able to take it and run with it. Otherwise, you can be stuck fighting over who's an administrator for months or years.
Oh, absolutely.
And they get paid for that position.
The private fiduciaries.
They do get paid.
Or isn't there a certain percentage that they get of the estate?
There is a percentage, yeah. It's 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, 1% of the next 9 million. And then reasonable fees after 10 million. But frame of reference for $1 million estate, it's 23,000 bucks to the attorney, 23,000 bucks to the administrator. That does not include extraordinary fees.
Yeah.
Extraordinary fees are things like selling real property. So,
Yeah.
so all of these things that you guys encounter as brokers and agents are all going to cost extra
Yeah, we're
for the estate.
Yeah, we are
we're
extraordinary.
extraordinary fees.
Exactly. Let me see. Determining what assets are owned. Again, if you don't have an estate plan, you don't have some list of your assets, this can be a real challenge. I represent private fiduciaries, and there's plenty of times where we take over cases and we end up sending out inquiry letters to like 50 financial institutions.
Wow.
Because nobody knows where anybody had assets, right?
Yeah.
They go, we didn't manage their affairs. There's no list. And so sure, we can go pull tax returns and find old K1s or old 1099s, but that may not be totally inclusive. So
Yeah.
there's a fair amount of work that goes into finding all of the assets. And again, all avoided by simply having that all jotted down while you're still alive and able to convey that info. When we're talking about real estate, the client's role becomes secondary to the attorney and the realtor,
Yes.
right? They steer the ship and they are the ones that facilitate the sale. And it's going to require working in concert because you've got to identify, are we selling through probate? Are we selling through a trust?
Mhm.
Can we avoid the probate even if it's not in the trust through my aforementioned Hegstead petition? There's a bunch of different considerations that go into this. And they all have different processes. So it's really important that the attorney and the realtor are on the same page.
Yes.
And you don't have,
Yes.
you need the right hand knowing what the left hand's doing, right? Because I have had plenty of situations where a realtor comes to us late and says, hey, we're closing escrow tomorrow. Turns out the house wasn't in the trust. The title report just found that. And it's like, yeah.
I will never do that to you, Adam.
I know you wouldn't, but we've had it happen. And it's like, yeah, guys, it's a problem. Or we've had people come to us and say, we just got our estimate on capital gains. There's going to be a $600,000 capital gains tax on this sale. We didn't realize that. We didn't realize that this is a true story. True numbers, true story. We didn't realize this apartment complex was in a bypass trust. And so now when we go to sell it, we didn't get a step up in tax basis of this property when the second spouse died. And I said, they called me again the day before, it's always the day before. And I said, get an extension immediately. And we ran down to court ex parte, and we got a court order terminating that bypass trust, saying it doesn't exist, pretend it never existed. Everything was really owned by mom when she died, wink, nod, zero taxes due.
Right.
Zero. So we saved them $600,000.
Wow.
I would say that kind of thing is worth a phone call
Yes.
to an attorney before you get to that point, right? Just identify these things. Hey, we're selling from a trust, or we're
Yes.
selling from an estate, and having the realtor and attorney on the same page is going to save the client a whole lot of headache and a whole lot of money very oftentimes.
Well, and you brought up a very good point, Adam, is that when someone does pass away,
Mhm.
a married couple,
Right.
it's so important to get a historical appraisal too for that capital gains tax to get your step up.
Yeah.
I mean, it is not saying that they're going to sell when the
Right.
person's still alive or dead, but anyways, it's so
Yeah.
important.
It is. And well, there's another reason too. You can also use that if it's a rental property, for instance, that sets your new depreciation amount. So you restart depreciation at the new higher cost basis. So for anybody who's not familiar, what we're referring to is cost basis, which is used to determine capital gain if you ever sell assets. So if you buy a stock or a home for $100,000 and you sell it for $200,000, there's $100,000 of gain in there. You're going to be taxed on it, call it roughly 33% with California and Fed. However, if property is inherited, and it works between spouses, and then it also works with other family members, you get what's called a step up in basis. So that $100,000 stock, if it's worth 200,000 when the person passes away, the cost basis goes from 100,000 to 200,000. So you could sell that day, no tax due. Swipe of a pen, no
Right.
tax. So it is really important to set that new value going forward. Definitely.
Very.
Let's see, fair market value, we talked about, you're going to use an appraiser for that.
Yes.
Um,
Because it is so important, because I did sell a home last year in Los Altos Hills, and her husband bought it back in the early 90s.
Yes.
For 600,000, and we sold it for 2.7 last year. So, and she never did a step up historical appraisal. So it was so important for her to get, and her husband died in the early 2000s. I mean,
Yep.
it didn't save them, it saved them a lot of money. I mean, still, she has a big capital gains, but you know, it's not as bad as if they bought it for 600 and sold it for 2.7. So
Certainly, yeah, no, it's a big deal.
it is a very big deal. So Victoria and I always ask when there is, we always do ask, no matter, we don't know someone's history.
Right.
Do you have a trust? Has someone passed away in the trust? Are you know, tell me a little bit about the house, or about the history of this house and how you guys bought it and all of that.
So I think it's true for you as well, Adam, just as it is for us and what we do. The conversation goes way deeper than just talking
Yes.
about, you know, a house, or you
Certainly.
talk about just a trust. There's family components, relationship components, history that really guides both of our industries and how we serve.
Exactly. And there's like, and then last year also, or no, actually a couple months ago, I sold another house, but there was 3 trustees, and one of the trustees was having such a hard time because it was the last house her dad bought, and
Yeah.
she didn't want to sell it. And it was a fight to sell it, you
It
know,
was
because
hard.
it was always something that she was coming up. So, and one of the trustees just said, thank you so much for handling my sister in such a kid gloves. But I think it's so important for people to realize that they do pick the right attorney and the right real estate
Mhm.
agent on how their history and how to go about selling their home.
It's important to take the time to have these conversations.
I
So
couldn't agree more. One of my favorite things about what we do is learning people's stories, right? How did you come to own 20 acres in Los Gatos? Oh, well, my uncle Vito came over from Italy. I mean, you get the coolest, richest histories with these families.
Yes.
And to your point, it really matters to them in how property is handled and
Yes.
how estates are handled, that all be honored, right? So it is important to understand these folks. We joke that what we do as attorneys in this area of the law is like 70% therapy, 30% law, because
Absolutely.
it's tough. You're dealing with what is oftentimes the largest financial transaction of anybody's life.
Right. Yes.
And it's right on the heels of oftentimes having lost somebody very close to them. And now, again, the most common thing is it's children. These are children that are usually grown adults, and they're now reconvening
Yes.
for something that for a very long time, except for very unique families, for a very long time, they have not had to work together, and certainly not on anything business or financially related. And so this is not an easy process.
No.
And you do have to help people through it. And, you know, the best advice I give people in dealing with those dynamics is give the other people benefit of the doubt. Don't
yes,
assume the worst. Don't assume they're trying to take advantage of you or undercut you or something. Assume everybody's trying to do what they think is right for everybody.
They do.
And if they prove you wrong, great, we'll go sue their ass. Great. Fine with me, right? I love it. It's fun to litigate. I get to go get my competitive juices flowing after not playing sports for a long time. But that's not what you want to be dealing with when you've just lost a parent or a grandparent or a spouse, right? You want to deal with the issues at hand and navigate the family dynamics smoothly, or to the extent possible.
Yeah, and I think true, you give people the benefit of the doubt. And then I think with like Victoria and I and you, we do become therapy
Yeah.
and we do validate their feelings, because it's so important to validate a seller's feelings during this. My dad didn't want this done. And okay, well, what's your suggestion then? Instead of coming so defensive, because there are agents out there that think, you know, pat themselves on the chest and say, hey, I know it all and I'm the perfect, and they want to, you know, they get in their own way.
Right.
So I think that, so this conversation is about money and death and planning and everything like that. And all of those are very charged subjects.
Certainly.
I think that giving people the benefit of the doubt, to your point, Adam, and also listening. And for us, when we're speaking with clients who have just gone through a loss, and now they're having this conversation about, as you mentioned, the largest asset that they own or their family may have owned, regardless of whether it's a mobile home or, you know, a $15 million property. They're having this conversation and listening and really looking at their best interests as a professional is so important.
So
it's
important.
not, our clients are not numbers.
Yes.
As you mentioned before, there's not a one size fits all in this.
No.
Right.
It's important. So,
Certainly.
okay. We talked a lot about this already, probate, but here's the actual definition. It's a process by which the Superior Court oversees the administration of a deceased person's assets. During a probate, the appointed personal representative collects the decedent's assets, pays the decedent's expenses, and then distributes the assets to the beneficiaries named in the decedent's will or to the decedent's heirs at law, the people who inherit if the decedent did not leave a will. So that's a beautiful definition straight from your website, Adam. Thank you.
Yep. It's a very long-winded way to say probate is collecting someone's assets, paying creditors, distributing the assets.
Yes.
That's it. It's 3 steps. It has a lot of nuance and smaller steps that go into that, but that's really what it is. Handling taxes, handling properties, liquidating assets if necessary, and distributing out.
How much does it cost?
Great question. It's very expensive, relatively speaking. So if we were to say, look, your standard, what we call just like a mom and pop trust, maybe they've got some retirement accounts, maybe they own one house. Let's just say it's worth, you know, 1.5, 2 million bucks. What does that cost for a trust administration? Very little. 5, 10, maybe 15,000 bucks. Complicated trust administrations, don't get me wrong, can be very expensive. However, probate is invariably more expensive. And it's for a number of reasons. One, there are set probate fees. Like I said, it's a percentage. You're going to get a percentage right off the top going to both the attorney and the administrator. That's not insignificant. 23,000 on $1 million bucks. But what I think is not appreciated or understood very often is that number used to compute the fee for probate is gross. So if you have $1 million house with a $900,000 mortgage, it is not a $100,000 probate. That's a $1 million probate. And so everybody's getting 23 grand based on that valuation.
Yes.
So that's important to understand. Again, comparatively speaking, trusts will always win out. It is so much cheaper to administer a trust than it is to handle a probate. Trusts can be administered far more quickly because you don't have the inherent administrative delay of going to court, getting, you know, court orders, etc. Before I jump into the next one, Nick, I see your hand is raised.
Yeah, I appreciate it. I do a little bit of a time check here. I know we have a question from one of our audience members, and we're coming up to the hour. So I'm wondering if we can maybe go to that last slide, do a quick summary on that one. But we do want to make sure that we get this question into you guys so you can answer that live as well.
Absolutely.
What's the question?
Questions that we hear all the time, and I'm sure you hear as well, Adam. How long do I have to sell the assets and disperse the funds to heirs? And
Reasonable. You have a reasonable amount of time is the short answer. The long answer is if you're stuck in probate, it's likely to take a year to 18 months to 2 years.
Yeah.
Frankly, 1 year would be an incredibly fast probate. It can be done, but everything has to go perfectly.
Yeah.
We have many probates that go on for years for various reasons. It's very rare to have trusts take as long as a probate. It's just inherently longer to deal with a probate. How do I determine the value of property? You don't, right? You hire either an appraiser or, in the case of a probate referee who's a state appointed official. They have like a badge, like a sheriff. I really don't understand the whole concept, but they're just state appointed appraisers. And then the decision maker, again, in a probate we talked about, it's going to be whoever the court appoints, whether that's whoever was nominated in a will, or whether that's an administrator after petitioning when there is no will. It's going to be up to the court. Whereas with a trust, that's going to be the person that you've picked who's going to be in charge. And very oftentimes you're avoiding conflict number one by appointing somebody as opposed to leaving it to the whims of the beneficiaries to fight it out.
Right.
How does the money get distributed? This is a really fairly deep question, to be honest, because you can distribute in kind, where one person can take a house, one person can take cash. You can distribute pro rata, where you say everybody takes 1/4 of the estate if there's 4 people, or you can liquidate everything and everybody gets cash. So there's a lot of variation in there, and it's really important that no matter what you're doing, it's not something that's going to cause conflict. Okay, and I'll address that. It's the last thing on here. But anything that you know is going to cause conflict is probably to be avoided without some initial step toward reasonableness. When you're acting as a trustee or an administrator, you want to move closer to reasonable and conflict avoidance if possible.
Right.
Who pays the taxes? Who pays the taxes is the same person that's going to pay the legal fees, which is the estate off the top.
Right.
Okay. So whether that's property taxes due to a reassessment, the state's going to pay it. Whether it's estate taxes because you've got a massive estate, state's going to pay it. Income taxes on the sale of properties, most likely the estate's going to pay it. The trust's going to pay it. There's some maneuvering you can do in here in how you handle taxes, but for the most part, it's going to go through the trust or the estate unless a decision is made for some tax benefit not to do it that way. Same thing for legal fees. Now, what if the heirs disagree? My favorite. This is where we really get in there and have fun. Everybody gets their own attorney and you all go to court and it drags out forever. And the attorneys make a lot of money.
Yeah.
I mean, I'm stuck in a huge case right now. It started in 2019. It involves a trust and 2 probates. And so far, just one law firm's attorney's fees are 2.6 million.
Wow.
That's just one. There's like 7 attorneys on this case. So it adds up very quickly. And that's what happens when, and it's an extreme example, but that's what happens when there is conflict amongst the family. So to be avoided.
Right. Yeah. I liked what you said earlier. It's very important for everybody to give each other the benefit of the doubt, if at all possible. So
it's huge. It's huge.
It's huge. In closing, I mean, speaking for, of course, Cindy, myself, and everyone in Amare and Adam, we're here to help. We are service providers in this process. So all of our contact information is there, and whatever we can do for you, whether it's referring you, of course, to Adam for estate planning, just questions. All of us are available if you have questions. I called Adam a few times with some questions out of the blue, and he's always had great advice for my clients.
I love to be a resource.
Yes, you're amazing. We really appreciate you, and this has been awesome. Nick, we'll leave it over to you now.
There you go. Well, we actually have a question that I'd love to see if you guys can answer it. We will be recording this session for those that are listening. You'll be able to go on to the Morgan Hill Chamber of Commerce's YouTube site and hear the recording again. But one of our attendees said, if you forget to put property in the trust, can you just write something saying the property should have gone in, and is that sufficient until you have an attorney added to the trust?
Short answer, this is not legal advice, since we're getting recorded.
I understand.
Careful here. Short answer is go see your attorney. Long answer is probably, but it depends on what the trust says. But probably it would work, but I can't say with any great deal of certainty, and it certainly wouldn't be my advice.
Right.
I've had plenty of calls and text messages with people that say, hey, I'm getting on a flight. Should I do X, Y, and Z? And it's like, not really, but it's better than nothing, which is what I would say here. Is it perfect? No. Is it better than nothing? Yes.
Right.
Okay.
So it speaks to intent. So
Yeah, certainly.
Well, Victoria, Adam, and Cindy, first on behalf of the Morgan Hill Chamber of Commerce, I want to thank you actually for truly an enlightening session. I mean, some of my walkaways, and I have a whole list of notes here, is you provided some great clarity, right, on the complexities, the nuances, and some of the misconceptions in recent involving estate planning. So I want to thank you for that. I also made a couple notes that you really need to put this in motion earlier than later, and then to have almost annual checkups because laws and regulations change. So to make sure that you're up to speed with the current environment, I think will be vitally important. So I wanted to thank you all for sharing your subject expertise on today's seminar. I also want to tell our listeners to stay in tune for the next in our series of educational offerings that we'll be initiating with Amare Realty Services in the very near future, as well as many other pertinent business and consumer workshops in our upcoming months. So thank you all for attending. Look for it on the YouTube channel, and we'll see you in the next series.
Great. Thanks for having me.
thank you.
Bye.
Bye.